All right, good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
All right, we are here on defendant's amended motion for attorney's fees and litigation expenses. Now, it's defendant's motion, so I'm going to let defendants proceed first. And if we could, like to proceed first just on the question of whether attorney's fees and litigation expenses should be awarded. And I'll give Ms. Baer an opportunity to respond to that. And then we'll see where we go from there.
Very good, Your Honor. Defendant's motion is brought under two different code provisions, 14.2.746 and 9.15.14. I'll address each in turn. OCGA 14.2.746 is specific to derivative actions, and that statute provides that the court can award fees if against a party that maintains claims that lack reasonable cause. Here, Ms. Baer repeatedly represented to the court that all she wanted in this case was for Health Discovery to hold a shareholder meeting. But the facts are that before the complaint was even filed, Health Discovery had already agreed to conduct a shareholder meeting in the second quarter of 2020. That HDC actually did conduct a shareholder meeting in May of 2020, but Ms. Baer did not actually attend the shareholder meeting. And the complaint actually alleges 6 different causes of action against 8 defendants. And the claims were substantially broader than just requiring Health Discovery to conduct a shareholder meeting. And both the defendants and the court at different times proposed that Ms. Baer drop the claims unrelated to the shareholder meeting, but she refused to do so. There was never any evidence presented in support of any of these claims. And Ms. Baer has waived the right to present any evidence today by failing to file a written response to defendant's motion. So as a result of all of these things, there's no record evidence to support any of Ms. Baer's claims. The only evidence before the court is that HDC promised to conduct a shareholder meeting in the second quarter of 2020 and actually did so as it had promised to do. For all of these reasons, Ms. Baer's claims lack reasonable cause as a matter of law, and the court should award attorney's fees under 14.2.746. In terms of the arguments, the arguments under 9.15.14 are essentially the same, Your Honor. That the standard is a little bit different. Under 9.15.14, the court can award fees and costs if it finds that a party brought an action that lacks substantial justification, or if its conduct during the litigation unnecessarily expanded it, including by abusing the discovery process. We believe that both of those elements are present here. For the reasons that I've already somewhat gone through under the other statute, Ms. Baer's claims lacked substantial justification. The statute specifically defines what lacks substantial justification means. It means substantially frivolous, substantially groundless, or substantially vexatious. And those words have the plain meaning of not having any kind of purpose or value, not based on a good reason, or causing harassment or annoyance. And all 3 of those elements are met here. As I mentioned earlier, Ms. Baer never presented any evidence in support of any of her claims. As a result of defending them, HDC has been forced to incur hundreds of thousands of dollars in attorney's fees and litigation-related expenses. And also, as discussed earlier, these claims really lacked any merit because HDC had already voluntarily agreed to the relief that Ms. Baer claimed is all she ever wanted before the lawsuit was ever filed. And finally, Your Honor, we've had several hearings and a lot of motion practice around discovery issues caused by Ms. Baer. She effectively refused to participate in any way in discovery, did not respond to discovery requests, refused to attend her deposition on 2 occasions, and required the defendants to repeatedly come back to the court requesting orders that she be compelled to do so. Finally, the court determined that Ms. Baer's discovery abuse is warranted the sanction of entering a dismissal of the case and a final judgment in favor of the defendants. Recognizing that Ms. Baer was, at least during parts of the litigation, a pro se plaintiff, the court repeatedly warned Ms. Baer that her continued failures to comply with discovery requests and the court's orders would subject her potentially to sanctions, including the dismissal of the suit and imposition of attorney's fees and costs. Unfortunately, Ms. Baer didn't heed those warnings. So for all of those reasons, Your Honor, we believe that the court should award attorney's fees and costs under 91514 as well, because Ms. Baer's claims lack substantial justification. Two quick points, Your Honor. First, Ms. Baer, it needs to be remembered, was the plaintiff here. She had the duty to, once she filed the lawsuit, to bring forth evidence in support of her claims. She never did so. There were 8 different defendants in the case and 6 different causes of action. And the relief requested in the complaint sought the unwinding of corporate transactions, including loans, the issuance of shares, and it would have required, ultimately, if Ms. Baer had prevailed, it would have required HDC to incur substantial expenses in convening multiple shareholder meetings. And so HDC was justified in defending itself against these claims, and Ms. Baer was obligated to pursue them. She didn't. Finally, Your Honor, I think it's worth mentioning, this probably goes more to the reasonableness, but it is important to understand that the real losers here are HDC shareholders. The total amount of fees that are being requested today by the defendants is equal to approximately half of Health Discovery's annual operating budget. And so it's not an insignificant amount of money for this company. So for all of these reasons, Your Honor, we believe that an award of attorney's fees is appropriate and should be granted.
All right, thank you, Mr. Whitkin. All right, Ms. Baer.
I'm sorry, can you hear me now?
Yes, I can hear you.
Okay, thank you. First, I didn't willfully break your reasonable demand to appear for deposition. I wanted nothing more than to have the opportunity to present my case, which is wholly justified in fact and law, the laws of the state of Georgia and the bylaws of Arizona. I very specifically, and my bylaws of our company, I do specifically remember you making it as plain as day that I had darn well better do it, no excuses. The last thing I'd ever want to do is abuse the court and lose my right, show you personally any disrespect after recognizing how patient you've been. And had I had the opportunity to present my case, I do believe that you specifically, Your Honor, were prepared to grant me a little leeway, maybe even a lot of leeway, for not knowing every rule and following everything to the letter. I tried. When I prepared the case that was filed with the court originally in DeKalb, and I think it was Health Discovery's request that moved it to Fulton County and then ultimately to your court. The lawyers relied on all the evidence that was in the public domain to bring the case. There's the things that I had requested from Health Discovery, or my lawyers requested from Health Discovery, were never even given to my attorneys. And I can show you where in one case, Dorothy Cornwell, my attorney at the time, had an appointment for review of records at their corporate office. This is prior to litigation, and I completely understand what I did is under your oversight, not this. But, and again, I'm owning my mistake. I hate saying owning my mistake because that's just such a catchphrase, but I do own it. Not only did Dorothy Cornwell show up to the appointment, she waited in their parking lot and got in touch with their lawyer and said, "You told me to be here at this time, and I can provide you with this." "Oh, we didn't tell you. Oops. Marty Del Monte had a meeting come up and we emailed those records to your partner who was in another state." And indeed, they didn't even email those records. So it did show up on my bill. So if anybody was abusing the system of trying to wear the other party out and cost me extra money, it was them, not me. Coming back to the fact, I still apologize for my screw up to you. They also have misrepresented to the court that I abandoned the suit, yet I have an email conversation with the court, my attorney and their attorneys stating that we understood the delay due to the COVID pandemic and could not justify rushing the emergency hearing along in light of the pandemic. So again, they've misrepresented that. Doesn't forgive the fact I didn't show for my deposition. I'm sorry, it's not so much that I'm nervous being here as much as it's, I somehow want to establish to you that my claim was substantially justified after making all of my apologies. The laws state that they have to have a shareholder meeting, that a individual shareholder can demand it. And I can give you the Georgia law. It was all in 14-2-701 and 702 as a single track. And the meeting that they claim to have had was not a meeting that justifies the laws of the state of Georgia or our bylaws in any way, shape, or form. I didn't have an opportunity to present evidence to you because we never made it through the discovery stage, and any information I had previously requested from them, they never provided anyway. My case relied on the evidence that was essentially part of the case. So I only could present the evidence that was given to me. I should have gotten more in discovery. When we first met in person, it was regarding their motion to dismiss my claim, and you didn't dismiss it. You did say it would be interesting. How can they say they had a meeting? I want to hear your case. So you didn't dismiss it. But secondly, in 8K, they point out that another shareholder, Lori Venning, brought a similar claim, if not identical, in the federal court. That case is currently in the discovery phase of, in that particular court. And in one issue that the federal court denied health, dismissed, The federal court did not allow Venning to request the records in the format that he did because he requested it of each of the individual shareholders. I mean, each of the individual defendants. The court said that he should have requested it from the corporation. I had made requests from the corporation and that was denied as well. But the fact that this is now in the discovery phase in the federal court is relevant. They did not dismiss it. They, as much as you didn't dismiss my claim, the federal court has not dismissed the claim. Repeatedly through their arguments with me, they keep bringing up DeKalb County. Well, there's other cases against Health Discovery that are still pending in DeKalb County. Mark Moore's was dismissed, and then I believe the federal lawsuit listed their place of business as DeKalb County. Let me see. See, discovery is when evidence is gathered. I couldn't gather more evidence for two reasons. One, they wouldn't give it to me anyway. And two, we never got to the point where I could present it. It's all part of the complaint. I can quote you the laws and all the filings that show you where they say they issued themselves stock. I can show that the stock, and it is in my case, was never issued. We still don't know what stock was voted and if it even exists. I personally don't think I owe anything. I didn't do anything intentionally or willfully. Attorney's fees, as I understand it, are awarded when litigation is brought to harass or when discovery is designed to be abusive, like in the case that you once referenced, Brindle versus Rogers. And in that case, you did award attorney's fees, but it was clearly an egregious abuse. Fees may be awarded with unnecessary requests. HTC's abuse the system. They've made unnecessary requests and misrepresentations. I have answered all of their questions. They clearly were trying to fish or, I don't know, come up with something embarrassing by deposing me. I wish I had been deposed. I haven't done anything wrong. All I have done, it is a matter of a direct claim. I can even give you the email to my attorney that says I do not want any partners in this case. I am actually asking for a meeting. My attorney said the other things had to be in there because we wanted to make it clear to the court that they were trying to vote stock that didn't exist. As a layperson, I would have worded it differently, but I was just trying to make it a point to say to you right now, there's 300 million shares outstanding as of the date I made my demand or request for a meeting. And these are the shares that are entitled to vote, which is substantiated in law that the date of the meeting should be the date that I demanded it. I have so much I could give you, and none of it they haven't provided proof that I've caused unnecessary damage. They claim the exact same cases existing in federal court also.
Ms. Bear, let me ask you this, and you've referenced it again, these other claims. And I think you just mentioned that, your prior attorney felt like you needed to have these other claims in there. We had a specific discussion about those other claims.
Yes.
And, specifically whether we needed to go forward on those other claims, because those other claims ask for some pretty substantial relief, unwinding of transactions, repayments of loans. Why didn't you drop the rest of those claims then and just go forward with something that we could have proven simply whether there was a proper shareholder meeting or not?
Because what I was trying to establish was that the shares that they were demanding to vote didn't exist. They were stolen even out of thin air. You know, the company had 300 million shares outstanding, and suddenly they've been voting themselves things that don't exist and making loans to the company that were, you know, 200%, 300%, plus giving themselves right to buy stock at sub penny without having tried to negotiate any other further loans.
Where is the evidence of that?
In all of their 8Ks.
Where in the 8K?
Well,
Say I'd love my day.
I'd love to have my day in court, and if you want me to just spend the next few minutes pulling them out, here, wait, I'll show you. I found one, and this one, I'll scream if I can't find it. Between, and incidentally, on the issue with what I've been going through with my mother, she's almost 85.
Yeah, let's
Just want you to know.
I'm aware of you, and you made me aware and the parties aware of the health issues with your family, which we are sympathetic to, but cannot be a part of this proceeding.
Okay. I don't know this word. Pardon?
Here's the issue.
I'm looking for the one that I saved.
Okay.
I can believe if I can find it. It's one page. One page about. Let me bring it up on here. Okay, all of this is taken from their 8Ks, but it is a shareholder who quoted the 8Ks. His name is Paul Bechtold, and he wrote, "Why don't we all get on the same page? The first order of business for you scumbags, first and foremost you, Corp, and now the rest of you," which he's addressed this to the defendants, "whom I believe are nothing but thieves, was to represent shareholders. Funny how shareholders have always played second fiddle. As you know, I put a lot on the line for this company to try protecting it from outside predators like Neo. You make them look like saints. Turns out the biggest predators of all have been insiders. Time for the..."
So here, okay.
Okay,
I hear what you're referring to.
Can I quote the 8K? "You've agreed, additionally, on June 1st, Mr. McGovern and the company have agreed to set aside accrued wages for Mr. McGovern. Mr. McGovern will forfeit the accrued wages for the following consideration. Then the board of directors approved the conversion of up to 50% of McGovern's accrued wages as of December 31st, 2019 into common stock, and the remaining balance will be converted into a note payable to Mr. McGovern. The conversion of the accrued wages and the convertible feature of this note payable will convert into the common stock at a conversion price of 0.0138. And there's way more to, in connection with the election, the board of directors, in recognition of their continuing contributions to the company, on June 1st, 2020, the company granted to Mr. William Fromhauser, Mrs. Colleen Hutchinson, Mr. Ed Morris, and Mr. James Murphy each a one-time cash payment of $20,000, as well as an option to purchase 3 million shares of the company's common stock. Additionally, the company granted to George McGovern and Mr. Marty Del Monte each an option to purchase 5 million shares and 4,500,000 shares respectively of the company's common stock. Furthermore, the company agreed to increase Mr. Del Monte's salary by 25,000 to 150,000. That's, I mean.
So all right, so let me stop you for a second. So their filings state that these things were done. what evidence did you have that they were illegal?
The laws,
What laws?
Proper shareholder.
improper shareholder laws. I can, improper shareholder meeting. And no, for instance, shares can't be issued specifically unless they've been voted on and approved by the shareholders, which I could go back to the Georgia statutes, and they hadn't had that. I also can show you where they claim to have made changes to the corporate bylaws, but they didn't file it till a year and a half to 2 years after they claimed to have done it, which was after this was started. I'd love the opportunity to forward it to you with it highlighted.
Your Honor, if I may just very quickly, it seems like Ms. Bear is being assisted by somebody off of the screen who hasn't appeared here. If she's going to participate in this hearing, I'd ask that she formally appear and show up on the screen or not participate, one or the other.
And we can hear her feeding things and then Miss Bear repeats them.
I hear it too, and that was going to be my next question. Council already brought it up. Who is off screen and who is talking to you?
I'm Miss Bear's daughter, and all I'm doing is shuffling papers that she has labeled.
Okay. It sounds like you're suggesting answers to her as well.
I couldn't suggest answers. She has papers labeled, and I'm trying to find them and shuffle them and give them to her that she printed out.
Can we have her full name for the record?
Samantha Bear.
All right, Ms. Bear, I'm going to ask that you not speak.
Okay.
Your Honor,
All right, Ms. Bear, you've answered my question as to what information you had for those other claims. So I don't have any more questions for you. If you want to continue, if you have more to address on the issue of whether attorneys' fees should be awarded, I'm ready to hear it.
I'd like the opportunity to submit everything I printed out to you in writing.
Now, here's the issue. You know, this issue has been noticed. You requested additional time, which we gave you, and now is hearing day. And it's too late. It's frankly just too late. What I needed to hear, I need to hear today. What I need to see, I need to see today. And we need to move forward. So the request for supplementation, that's denied.
Can I hold it up and show it to you?
You can show me what you want to show me.
Oh, also, I'd like for the records to not be sealed because it doesn't serve the public interest. I feel that one of the punishments or sanctions that a court has the right to do is to dismiss the claim. My claim is really, really good, and taking that opportunity away from me was a huge sanction. I've let myself down and I've let the company down already. Repeatedly, this is from Westlaw. I'm looking for where I highlighted things. And actually throwing my case out was significant and substantial. There's so much now that's before the court. These directors aren't actually even legal directors, in my opinion, and I was honestly hoping to have the opportunity to present it to you. But the things and negotiations that they have entered into will probably be a good reason for companies like Intel to not even have to honor anything they agree to. And they're not allowed to justifiably make offers and accept offers part of the company. I'm so mad at myself. And all of this stuff is in the court. Here's the characterization of the email to the court. While we agree with the characteristics of the plaintiff's need for relief, we ask the court reset the hearing as soon as practical under the unprecedented circumstances. That again was where Health Discovery kept saying we abandoned it. Unfortunately, we don't expect the court to be able to meet on an emergency basis before May 27th at the shareholder meeting. In terms of actually having held a shareholder meeting, they did not meet the requirements. Yes, in their proxy, they say the shareholder list will be available to all the shareholders at the meeting and at the corporate office for 10 days prior to the meeting. That was a disingenuous representation because the country was in lockdown. There weren't even enough masks for people to go out in public, let alone go to their corporate office to review those records. This is they claim in their 8K that I was working with Venning and Corp with no evidence. This is Lori Venning sharehold the derivative claim he filed in court. And I also have the court's response granting most of the motion, ordering it to proceed into discovery. The request that I made for discovery that they refused to give, this is the email conversation between the attorneys saying, you didn't show up, I'm sitting in the parking lot, and that showed up on my bill. And then their response saying, oh, we emailed it to someone else, and then talks about why they said Mr. Corp isn't entitled to it, to the records, even though his request was consistent with what the federal court said was a legitimate request made directly to the company. It wasn't willful on my part. And as much as I may have told you to the degree what my mother's been through, you couldn't possibly know what mental anguish it has been to me. It's been multiple hospitalizations during COVID. My husband had COVID requiring treatment in the hospital.
Okay, I'm going to stop. I have to stop you there. That can't be
extreme. I just want you to know it was extreme. And I reached my breaking point of how much any one person can handle. But my claim, I would love to have an opportunity to have presented it. And that was the biggest sanction you could have given me, was to throw my case out. I mean, their additional cost was a court reporter. I'm beyond sorry. I missed an opportunity that I realized you were giving me.
all right. Thank you, Ms. Bear. Mr. Whittakin, you have a last word on the issue of sanctions?
Yes, Your Honor. A couple of very brief points. Number one, Superior Court Rule 6.2 requires responses to be filed. If you fail to file a response within the appropriate time, then you've waived your right to present evidence at the hearing. Ms. Baer wasn't sworn in, so the court shouldn't consider her discussion as testimony or evidence. It's merely argument. And it was unclear to me the sources of the information. Everything that she said was essentially hearsay. I don't even know what she was reading from. But most importantly, Your Honor, at the beginning, the court's question was very simple: is what evidence do you have in support of your claims? And in all of Ms. Baer's response, I didn't hear any evidence that she had to support any of her claims. And so for that reason, we think that the motion is well-founded and should be granted.
All right. Here's where I am on the motion. You know, my first substantive review of this case was reviewing the papers on the motion to dismiss. There was a response filed, and there was a hearing. And everything up to that point of the hearing led me to believe that there were validly pled claims that were going to require substantial diligence, substantial effort, specific expertise, and likely legal expertise and substantial discovery to prove, but that they pled a claim. And I did not think the claim was without substantial justification based on what I could see then in the record. And sometimes these claims prove to be unjustified with discovery, and sometimes they prove to be justified with discovery. But what was clear to me was that after Ms. Baer lost the benefit of legal expertise, it was going to be a heavy lift to get this case past summary judgment. And at every turn, I advised to the best of my ability, Ms. Baer, of how difficult this process was going to be, and offered her every opportunity to back away from the more complex, substantial, and difficult allegations to prove, and invited her to prove what could be proven easily and efficiently. She did not take that opportunity. And we have heard from very early on, from the first status conference I had, I've heard Ms. Baer, I've heard from Ms. Baer, I have seen on the screen her mother, I have heard about family issues, I have heard about health issues that in some cases have worsened. This is not an excuse. What this tells me, Ms. Baer, is that you had a pretty good awareness that this was just not something that you could maintain, that you had the mental space, the family space, the expertise to maintain all these claims. Yet you kept them out there anyway, and you forced the defendants to have to defend it. I appreciate and accept your apology for not following my directive as to your deposition. But what that does not take into account is the multiple hearings we had where documents and information and your appearance was requested and not given. And I accept that there are family issues. It's an explanation, but it's not an excuse. If you're not able, for whatever reason, to participate in a lawsuit, the response is a voluntary dismissal without prejudice until you can get it together, and then to refile the case when and if you're able to prosecute it. You didn't do that. You forced the defendants to have to continually press, continually come to me, continually press to move this case forward or to leave it. And that didn't happen. So I do believe that under 9-15-14B, you unreasonably expanded the proceedings. And I believe there was other improper conduct that unnecessarily expanded the scope of the proceedings and caused the defendants unnecessary trouble and expense. Now, I am awarding sanctions under 9-15-14B. The next question is the amount of those sanctions. I'm going to turn back to defendants to talk to me about the amount.
Thank you, Your Honor. So we have filed an affidavit of Ms. Berg, who is the senior partner on this matter. It was filed, I believe, last Friday. That affidavit attached as exhibits all of our firm's invoices through, I believe, July 31st of this year. That would be the evidence that we would rely on. Ms. Berg, of course, is here. We could swear her in and I could present her testimony if the court would prefer. It's really just a matter of what the court would like to hear.
I think that her specific testimony is unnecessary. I think we've got it under oath on the affidavit supported with unredacted billing statements that have been shared with all the parties.
If I may, Your Honor, I apologize. I should have mentioned this before. It's a housekeeping matter. We did go back and look at the invoices one more time and have agreed to reduce them further. I felt like all of the entries relating to the DeKalb County action should not be charged against Ms. Baer in this case because it's a different case. And so we went back and pulled out approximately 33 hours. It's a reduction of our requested amount of $15,736.50. And so I can provide the court with an invoice of, well, a highlighted invoice showing the entries that we would further agree to pull out of our fee request, but assuming that we pull those out, the total amount requested now is $208,545. I'm sorry, I forgot to mention that earlier.
All right.
I have one more housekeeping matter is we only filed the redacted invoices on the docket with the court. The unredacted invoices were provided to the court and to Ms. Baer. So I just want to make sure the record is clear. That's what's on file and available are the redacted invoices.
Yes, and my intent was to grant the motion to file under seal. So, you know, if you want to make the filed record complete, you're free to file them under seal. I don't think that's absolutely necessary since in effect we have them and I'm looking at them, but if we want a complete filed record in our.
That's probably best. So we will take care of that. Thank you, Your Honor.
All
Your
right.
Honor.
So Ms. Bear, so go ahead.
I'd like to add, I don't think I've made it clear the amount of depression and mental health crises that I've personally been under. I can provide it from a psychiatrist that I've been seeing through this. It's well documented, it's significant. I wanted nothing more than to make my case. And I don't know how to apologize more, but there's still this claim is significant. It's still being presented in federal court. And I can hope that that goes somewhere, but I've barely been functioning. I mean, obviously I'd like to provide that documentation privately, but it is significant. And I don't want to say something publicly that
And we are streaming live, so if there's, you know, personal medical information, you know, don't disclose it publicly.
but if I had even known, and again, this is my flaw, one, from not being a lawyer, and two, just being just where I am, I would have asked to stay this until I could have had time to do it properly, but I can't. I don't have the energy. You did sanction me significantly. And no, I don't want to submit publicly what my issue is, but I will privately do that.
So we're talking now, Ms. Bear, about the amount of the fees. Have you had an opportunity to review what Ms. Berg submitted in terms of her affidavit and the billing statements?
Yes, and from the little I understand, when sanctions are granted, it usually is for the, it should just be to the cost of my missing the deposition. The case itself is substantiated. My not showing up for the deposition, I can understand why that could end up on my bill. The case is being tried again in federal court, and it hasn't been dismissed, and you didn't dismiss it. That's legitimate. And the fact that I didn't have enough sense to say right now, I don't have the mental capacity myself to pursue this, or the time because of the other things I was dealing with. That is my stupidity, but that didn't cost them money. It just seems like it should be limited to my missing the deposition.
All right. Mr. Wedekind, last word if you want it.
Your Honor, we believe that'd be insignificant. And again, like the court, the defendants are not unsympathetic about Ms. Bear's personal issues. However, these amounts of these invoices represent actual out-of-pocket costs that have been borne by the defendants. These are real dollars and cents that have been incurred and paid as a result of Ms. Bear's decisions. And so we believe that the court should not limit itself to a few hours, that really the full amount that's being requested should be ordered.
And aren't those things going to be reused in what you characterized as identical litigation?
I don't think he needs to answer that question, and I don't think it plays any part in what my ruling is going to be. Here's where I am on this. You know, as I mentioned, you know, there was some substance here through the point in time that you had counsel, and I hear you and credit what you say about reliance on what counsel told you. But at some point, it became clear, as I mentioned before, that you weren't going to be able to carry this through for whatever reason. And that was the time to stop. And when we had that hearing in November of 2020, and I gave you the opportunity to pare it down, and we went forward, my ruling is that's when attorney's fees started to accrue. Because we never got past that point. We never got past that point in discovery. We never got a cooperation and an appearance at a deposition. And ultimately, they had to file motions to compel, they had to have hearings, they had to file a motion to strike and a motion to dismiss. All of that is compensable. So my intention is to award attorney's fees under 91514B, all fees reasonably incurred from November 2, 2020 through the present. Well, I will take a look at, we'll take a look at the billing statements, and we'll try and total it up from that point. If counsel, I invite counsel, if you want to help me, if you want to help me do that with a number y'all think is right, I invite you to draft and submit a proposed final order and judgment that encapsulates my ruling on 91514B and the total amount. My rough estimate is that it's in the tens of thousands, but not in the hundreds of thousands. Probably low to mid tens of thousands, which I think is an appropriate sanction in this case.
Good, Your Honor. We will draft a proposed order for the court.
All right. I think that concludes our business for today. I'm going to excuse the parties. Ms. Bear, you know, final order and judgment is going to be entered. You'll have some legal rights and some legal options after that judgment is entered. I assume you'll do your research and make your decisions accordingly. From there, that order will be appealable, and that'll be up to you to decide where to go from there. So that is all. Everyone can be excused.